What is an order instrument? It is one which on its face is payable to the order of a specified person. It can be negotiated only by the endorsement of the holder. Okay? Can be negotiated only by the endorsement of the holder, completed with delivery, unless the last or only endorsement is in blank or to bearer. So, this order instrument is the opposite to the bearer instrument. Okay, let's go with the problem. Manila, June 22, 1999. Pay to Y or order 10,000 pesos. So, pay to Y, signed by X to Z. So, upon receiving the instrument from X, Y made at the back thereof the endorsement, pay to A or order, signed by Y. So, from X, issued it to Y. Now, this Y endorse it to A and make an annotation that pay to A or order. Okay, pay to order. We can say that this instrument is an order instrument because there is the word order, or whomsoever he or she instructs. So, in turn, A delivered the instrument to B, who paid value thereof in good faith. Okay. Upon maturity, B presented the instrument for payment to the drawee Z, who refused to pay the same. B gave notice to dishonor to X, Y, and A. Now, the issue here is, can B collect from X? Can B collect from X? The answer here is no. No. B is not a holder because the instrument is payable to order. So, who is the holder here? See, it is only A is the holder because it is an order to a specified person, only to be paid to a specified person. So, who is that person? It is only A. It cannot be in favor to B, pay to B or order. So, it cannot be because the instruction here is pay to A. So, A is the holder in due course, not B. To negotiate it, to transfer it to B, there must be a endorsement completed by delivery. Later, we will talk about what is that delivery, completed by delivery. So again, in order to negotiate it from B from A to B, there must be a endorsement completed by delivery. This is so because the only or last endorsement is a special endorsement. Why is it a special endorsement? It is only be only given to A. Only be given to A. It is a special endorsement. So the instrument is an order instrument. It is a special endorsement because it is only particularly or specified only for A, not for any other purpose, not for any other bearer, for not any other who is in the possession, who has the possession of this check, of this instrument. It would be different if the last or only endorsement is in blank or to bearer. That's why it will now be different if the last endorsement is in blank. Blank means no specified person, no specific person, blank, blanco, no name, or to bearer. Bearer means who is in the possession of the check. In which case, the order instrument can be negotiated by mere delivery. So again, this order instrument is only to those specified person. Specified person. From X, again, from X, issued it to Y. Then, Y annotate or make an annotation, pay to A or order. Pay to A or order, signed by Y. So, it means to say only pay to A, not to any other person, because A here is specified, because this is a special endorsement only for A. Take note, we can say that this is an instrument, order instrument, because there is the phrase, there is the term or the word order. So this is an order instrument only to a specified person, only to what is instructed. So the instruction here is only pay to A, not to B. So therefore, B is not a holder in due course. It is A is the holder in due course. Except, even though this is an order instrument, but it is in blank, pay to blank or order blank, there is no specified person, or specified if it is bearer, who is pay to A or bearer, ba? Pay to A or bearer. So therefore, from X issued it to Y, from X issued it to Y, endorse it to A, and then endorse it to B. So B is now a holder in due course in case of bearer instrument. Okay, again, in order instrument only to those who are specified, because this is a special endorsement. Okay, special endorsement, pay to the order of a specified person, while in bearer instrument, it is only payable to bearer, to whoever who is the possession, has the possession of the check. From the issuer A, issued it to B, then endorse it to C, endorse it to D, endorse it to C, so on and so forth. As long as this bearer instrument is in this kind of form, pay to B or bearer, so to any other person who is in possession of this check, of this instrument, can be a holder in due course. This bearer instrument is opposite to the order instrument, because in order instrument, only to a specified order, pay to the order of a specified person, except if it is already unless the last or the special endorsement is in blank. This is the exemption. Only endorsement is in blank, pay to blank or order, or pay to A or order. Pay to A or bearer. Bearer means who has the possession of the instrument, not to the order. So that's the difference between bearer instrument and order instrument. Now let's go to delivery. It is the transfer of possession. Can be actual or constructive from the obligations and contract. Actual delivery and constructive delivery. It is the transfer of possession with intent to transfer title. It consists of placing the transferee in possession of the instrument, accompanied by the intent to transfer title. So it's placing the transferee in possession of the instrument, accompanied with the intention to transfer title. Now, question, is receipt of the check by a collector, issuance, and delivery to the payee in contemplation of law? Is receipt of the check by a collector, collector issuance, and delivery to the payee in contemplation of law? No. The collector is not the person who can take the check as a holder. The collector of that check, collecting the check, is not the person who can take the check as a holder with intent to transfer title thereto. That is in Lim versus CA. So again, delivery is placing the transferee in possession, specifying that person to be in that to have the possession of the instrument, accompanied with it the intention, the knowledge of transferring title. When it comes to the collector issuance, no, they are just only simply a collector, an agent of the principal. So there is no contemplate the law does not contemplate it as delivery. There is no intention of transferring the title to the collector issuance. Incomplete instrument. What is an incomplete instrument? From the word incomplete, lacking in material particulars, like the name of the payee. As remember that payee is the one who will receive the payment. Payer is the one who will pay. Who will pay the payee. Lacking in material particulars like the name of the payee, the amount of the instrument. In other words, it is an instrument which has been signed by the drawer or maker without specifying the name of the payee or the amount thereof. So it means to say incomplete. The drawer, the maker, or the issuer just only sign the check, sign the instrument without specifying the name of the payee or the amount thereof. No name, no amount. A blank instrument may be lacking in some material particulars, but not the drawer's or maker's signature. Blank instrument may be lacking in some material particulars, but not the drawer's or maker's signature. Because if it is entirely blank, including the drawer's or maker's signature, it is not yet an instrument. Okay. We can say that a paper is an instrument if it has already the signature of the drawers or the makers or the issuer. Maker is the issuer of the check, and delivered it or issued it to the next person, to the person or to the payee rather. Again, the drawer or the maker or the issuer issues the check, issues the instrument in favor of the payee, the one who will be paid, because the drawee is the one who will pay the payee. Drawee is the payer who will pay the payee. That's the logic. It is not yet an instrument in the absence of drawer's or maker's signature. If there's no signature, it is just only a piece of paper. For a blank instrument to exist, the least that must be done is that the instrument must be signed. So we can say that it is an instrument, it is a blank instrument if it has signature of the drawer or maker without specifying the name of the payee and specifying the amount to be paid. Question: is the fact that the serial number of the check was altered a ground for the drawee bank to refuse to pay the check? Check, and then the serial number is tampered or altered. Is that a ground for the drawee bank to refuse to pay the check? The answer is no. The serial number is not an essential requisite for negotiability under Section 1 of the Negotiable Instruments Law. Again, in order for an instrument or in order for a paper to become an instrument, it must be, in order for that instrument to be negotiable, it must be in writing. It must be in written. And it must be affixed with the signature of the drawers, makers, or issuer's signature. The one who is making or executing the check, and specifying, or there must be unconditional promise to pay. Unconditional promise to pay. Such alteration is not material as it does not alter the effect of the instrument. That is in PNB versus CA 256. Now, incomplete instrument but not delivered. How is that? What is the effect of an incomplete instrument which is not delivered? Incomplete. Again, if we say incomplete, there is lacking material, the name of the payee and the amount of the instrument, but it is signed. Now, incomplete instrument but not delivered. It will not, the effect, what is the effect of incomplete instrument which is not delivered? The effect is that it will not, if completed and negotiated without authority, be a valid contract in the hands of any holder. it will not be a valid contract. Again, this is under section 15 of the Negotiable Instruments Law. What is the effect? The effect of an incomplete instrument which is not delivered, it will not be a valid contract in the hands of another, of any holder. So there's no valid contract there. It will not, if completed and negotiated without authority, be invalid contract in the hands of any holder. So it will not, without authority, as against any person whose signature was placed thereon before delivery. That is in section 15 of Negotiable Instruments Law. Again, incomplete instrument, even though there is the signature but not delivered, it will not be a valid contract in the hands of any holder, as against any person whose signature was placed thereon before delivery. It will not be a valid contract, and also it cannot be as against any person whose signature was placed thereon before delivery. No contract, and it also cannot be used. That incomplete instrument cannot be used against any person whose signature was placed thereon before delivery. That's the legal effect of incomplete instrument but not delivered. No valid contract, and it cannot be used against any person whose signature was placed before delivery. Next problem. A issued a blank check but does not deliver it. It was A who is the drawer here, or the maker. B stole it and filled up the amount and wrote his name as payee. Again, A here issued a blank check. It means to say A place his signature, make a signature in the check, but there is no specified name for the payee, and there is no specified amount. Now that check, the check of A, the blank check, was stolen by B. Now B filled up the amount and wrote his name as payee. B negotiated the check or endorsed it to C, who paid value therefore in good faith. Now C presents it for payment to the Rowi Bank, but the bank refused to pay due to the stop payment order previously given by A. C gave timely notice of this honor to A and B. Can C collect from A from the amount of the check? Obviously, there is something wrong here, because B stole it from A and B took advantage of the signature of A and endorsed it to C to claim money from C. So now here C cannot. No, the instrument is incomplete and undelivered. Incomplete instrument but not delivered. It does not constitute a contract as far as A is concerned, since A is a party whose signature appeared thereon prior to the filing of the check, and the check was filled up without his authority. In the hands of any holder, even a holder in due course, such instrument does not constitute as basis to make A liable. So here, in this situation, wherein A issued a check, incomplete check, because there is no name for the payee, there is no amount stated, and the signature of A was present. So that is already an instrument. It was stolen by B, and B, without authority of A, obviously it was already stolen, so therefore there is no authority from A. So B here wrote his name, wrote an amount, and endorsed it to C. So now C, in good faith, without exerting effort, um, by looking at the check, at the instrument, it's genuine. So go to bank and encash it. So here, C cannot collect from A the amount of the check because there is an incomplete instrument and undelivered. Incomplete instrument but not delivered. So therefore, the legal effect will be it does not constitute a contract as far as A is concerned. There is no contract between A and C, A and B. Then, it's because there is no contract, the signature of A appeared prior to the filing or prior to the filling up of the check. The signature of A appeared prior to the filling up of the check. And the filling up of B is without authority. And it will not bind A. There is no liability as far A is concerned. In the hands of any holder, even holder in due course, such instrument does not constitute a basis to make A liable. So here, C, the remedy of C is to collect from B, who fraudulently make a false instrument. So the remedy of C is to file a fraudulent case against B. Question: in the above problem, can C run after B? Yes. That's what we're talking about. Yes, B's signature appeared on the instrument after it was filled up. Moreover, B negotiated the instrument to C, endorsed it to C, and the latter paid value thereof in good faith. If B is not held liable to C, it will constitute unjust enrichment on B's part at the expense of C. Again, B's signature appeared on the instrument, signed already, signed by A and then signed also by B. So moreover, negotiated the instrument to C, then in good faith C paid it. Here, if B is not held liable to C, it will constitute if B is not held liable to C, it will constitute unjust enrichment on B's part at the expense of C. There is an unjust enrichment on the part of B at the expense of C, and the law does not allow that. Does not allow that. The law does not allow that. Does not allow that. Okay. Wherein B is enriching unjustly at the expense of C. So therefore, the remedy of C is to file for damages against B by filing also C should file a fraudulent case or stapa against B and at the same time claim for damages as an ancillary of the main case.